There has to be some common sense.
Yes, sir. They have the car stopped at 10th and Ranch by Kohberger.
We still don't know who pulled the trigger.
Hello, everyone, and welcome to Police Off the Cuff, Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, a 27-year veteran of the NYPD, retired out of Manhattan North Homicide Squad. And with me today, a fan favorite, Professor and retired NYPD Sergeant Michael Geary. How you doing today, Mike?
Very good, Billy. Thank you for having me.
You know, Mike, people like your calmness, your down low demeanor. They liked, of course, they love the New York accent, but Mike is a professor at Albertus Magnus College in New Haven, Connecticut, and he also, incidentally, has a law degree, so he can be our go-to guy with a lot of the legal issues here. You know, folks, everyone was expecting huge things today. Well, you probably shouldn't have from this hearing. And really, you know, someone said on the Law and Crime channel, it's going to be a nothing burger. I love that expression, nothing burger, you know, and it turned out, almost to be that, you know. And if you didn't watch, we're going to play a little bit of the hearing here. But one of the things is, like, it's all of this stuff has a lot to do with timing. And, you know, a defendant, they have the speedy trial clause in there, really for a defendant. But when a defendant wants to slow down that speedy trial thing, he absolutely has the right to do that. And in essence, what happened in the hearing today is that the defense slowed down the speedy trial, thing today, because guess what? Not a big surprise. They're not ready. They're not ready to proceed. There's a lot of things they do not know. And of course, the prosecution has no intention of letting them know right away. They'll comply with discovery when they have to, and no sooner than when they have to. Let the defense work. Let them find out things without it being handed to them on a silver platter. So the discovery process. So if you weren't watching this today, and again, we're going to play some of it, the next court appearance is not till June 23rd. So you may ask, like, well, why do they need that much time? And to answer that, I'm going to hand it over to Professor Mike Geary.
Thank you, Billy. Yeah, strategically, although a defendant in the United States, in any state or on the federal level, they have a right to a speedy trial under the 6th and 14th Amendments, and also the state amendment, also in their state law of criminal procedure. But tactically, they're not ready in this case, and they would love to get their hands on all of the material that the government has, and the FBI has, and the Moscow Police Department and the Idaho State Police Department. They'd love to get their hands on it, but they'll get their hands on it when it is statutorily required for the prosecution to hand over that material. Until then, we're looking at what we call due process. And the defendant, Bryan Kohberger, he enjoys the ability to be presumed innocent until proven guilty, and he needs to have what's called due process. So he's coming into court. He's been served with the arrest warrant, and they're going to look to get some discovery from the prosecution. They're going to set out a timetable with the judge for discovery and for a grand jury or a preliminary hearing to show probable cause. But the defense starts with their foot, one step behind the prosecution. They don't have the evidence. They don't produce the evidence. They don't have the investigators going out there. They don't have a laboratory that they can turn to look at DNA results or fingerprint results or anything like that. So therefore, they're going to need the time to hire their own specialists, maybe perhaps retired police officers, maybe retired medical examiners, DNA specialist to look at all the material as it comes in. So it's going to take quite a while. It's going to be a slow process. And tactically, it makes sense for the defense team at this point to not hurry up. The idea of a speedy trial in this case is going to hurt the defense. They need time to get their hands on the material and do their deep dive into material and see what the material presents to them, you know, the weaknesses in the prosecution's case and the strengths in the prosecution's case. So a June hearing date seems far away, and it seems like, oh, that's, you know, not fair to the defendant. But many defendants actually want to slow down the process. Absolutely.
You know, Mike, before this hearing on the next court appearance on the 23rd, won't the prosecution impanel a grand jury and get the indictment in there first? Well,
under Idaho law of criminal procedure, once a person has been arrested and it's a felony, they have it's actually considered a right to a grand jury proceeding. The grand jury proceeding was first written into our federal constitution back in like 1791, and it was only applicable to the federal courts. After the passage of the 14th Amendment, it applied to the state courts, and every state has, you know, their own grand jury laws written into criminal procedure. And that must take place if the person is incarcerated, like Kohberger is. They have to have a grand jury proceeding within, I think it's 10 court days, 10 business days. And it's very similar to New York. We have what's called the New York ability, if you remember from the day, way back in the day, something called a 180 day,
yes,
whereby if a person wasn't, indicted by a grand jury and they were incarcerated, they would have to be released. So all states have that sort of provision.
You know, Mike, what that meant to most cops was they would time that so that the grand jury day would fall on their day off.
Their RDO.
So they would get, right, with RDO, regular day off for you folks that are in coppers out there. Yeah. And so the officer would get 8.5 hours of overtime. So it was very much choreographed in that way.
Yeah, those are good days. So if the person is not in custody, they can go out to about 14, something like that, 14 business days. But it's actually good for a defendant to actually have a grand jury proceeding, because they will discover later on what the prosecution's witnesses said in front of the grand jury. A grand jury isn't a trial jury. A grand jury's job is not to determine ultimate guilt or innocence beyond a reasonable doubt. It is simply to, double check what the police thought about probable cause, what the prosecutor thought about probable cause, and what the previous judge who issued the arrest warrant thought about probable cause. So it's just a check, and it's actually considered good for the defense. And defense attorneys usually want to get those grand jury minutes in discovery. If they don't have a grand jury impaneled, some states allow also for what they call a probable cause hearing, which is slightly different, whereby it's an open court. I think Colorado does that, whereby if they don't have a grand jury in all of their counties, some counties will have what they call a probable cause hearing, and they'll dispense with the grand jury altogether. And the prosecution is required to bring in just enough witnesses in open court, in front of the defense attorney, in front of the defendant, in front of the juror, in front of the judge, and go over the material and just simply establish probable cause one more time.
Absolutely. You know, Mike, before I play the hearing, because it's very short. I was a little bit, not a lot bit, but a little bit surprised that the defense attorney didn't raise the issue of bail. And I think when we hear that, and this is a quadruple murder, we would shirk and laugh at that this guy should never, ever, ever. But in this new world we live in, you know, there's some craziness out there.
Sure.
That someone like this could even be or would even be, I should
Right.
rephrase that, would even be considered for bail. I think that would be absolutely ridiculous because he's a danger to the community. However, in New York, they don't even consider that anymore. A
No.
judge is not allowed in New York to consider a defendant's being danger to the community. I just, of course, that is lunacy. And that's why, everyone's leaving New York now because our politicians are out of their mind. I don't want to get political, but I just did. But just think of a judge not being able to consider danger to the community in granting or not granting bail.
I think the defense attorney knew that motion for, bail hearing would not be granted. But, the defense attorney is, obligated by the rules of their ethics to zealously advocate and for their client. So to not bring that subject up, could be considered, like being negligent in your duties. So the defense attorney, I could see the defense attorney doing it. It sounds strange to, maybe people listening in, but I could see the defense attorney doing it, saying, look, every possible issue that they could possibly raise at every single hearing to try and get, do what's best for their client. It's their ethical obligation. And so they knew nothing like that's going to happen.
Mike, I could just see an attorney saying, he's a PhD student.
Sure.
His family's here in the back of the courtroom.
Right.
He has ties to the community.
Right.
He owns a car. He's got the financial wherewithal to. I could just hear all of that in my violin. I'd start playing my Stradivarius as that was going on.
They could always ask, could you put the car back together and give it back to him so he could drive back to Pennsylvania 2,000 miles away? It's just it's one of those things that it seems weird and odd and crazy, but it's what the defense is trying to do. They're just trying to do their job as zealously as they can, and just do what they're follow their rules of ethics.
Absolutely. Let me play the hearing here.
CR 29222805. This is State of Idaho versus Bryan Kohberger. Mr. Kohberger is in custody. He is appearing here in court with his attorneys, Ms. Taylor, Mr. Logston, Mr. Thompson, Ms. Jennings appearing on behalf of the state. This is the time set in the matter for the preliminary hearing status conference. So I am going to inquire of counsel. Ms. Taylor, what's the status at this time? And Mr. Thompson, are you in agreement with that?
The state has no objection to that, Your Honor. And Ms. Taylor reached out to us by email yesterday with her proposal. On reflection, the state's calendar would be better in the month of July, but we will make the end of June work if that's the board's preference. And I haven't had a chance to talk to Ms. Taylor about that. I'm sorry, I know that's last minute.
That's okay. The court's calendar is going to be better towards the end of June, early July. So would that work, Ms. Taylor, for your scheduling on your other matters?
Your Honor, yes. If we take that fourth week in June, that's actually best.
Okay. So, Mr. Kohberger, I need to speak to you for a moment then. Sir, you do understand, and have you had enough time to speak with Ms. Taylor about your decision to waive your right to a speedy preliminary hearing?
Yes.
Do you need any additional time to do so?
No.
Then I will ask at this time, as to the 5 counts, felony counts that were charged in the criminal complaint that was filed on December 29th of 2022, are you waiving your right to a speedy preliminary hearing and agreeing that that hearing can be held outside the 14-day period?
Yes.
And Ms. Taylor, do you concur with his waiver?
I do, Your Honor. Thank you.
I will find your waiver of speedy preliminary hearing is knowing, intelligently, voluntarily entered here in open court with the assistance of counsel. We will go ahead and set the matter for preliminary hearing. Beginning Monday, June 26th at 9:00 a.m. And I will go ahead and reserve the week, so June 26th to June 30th, in the event that we need all 5 days for presentation of evidence. And just so council knows, it will begin at 9 a.m. each of those days. Is there anything further to address at this time in the case, Mr. Thompson?
Not from the state's perspective, Your Honor, no.
All right, or Ms. Taylor?
No, Your Honor. Thank you.
Okay. Mr. Kohberger, then you will be remanded into custody on your same no bail at this point in time, pending further proceedings. Again, we'll send notice out to council, and we will be in recess for this morning.
So that was it. That's basically the whole hearing. And the elephant in the room, and everyone's mentioning it in the chat, is the cuts on his face and the cuts on his chin. To me, they look like shaving cuts. But everyone wants to say, "Oh, someone beat him up in prison." I don't know. They don't look like wounds like that. They do look like shaving cuts. Look, I could be wrong, but that's what it looks like to me. The other thing is that I apologize. I was wrong. It wasn't June 23rd. It's June 26th. That's a Monday. You know, what's going to happen is they're going to come back on the 26th, and defense is going to say, "Your Honor, we need much more time. Could you put this off till September?" I know it's going to happen. And you've been involved in trials, and you know no one works over the summer.
No, the state is and the judge is, you know, they're entitled to their summer vacation. Things slow down even in New York City, as you know. Things slow down a lot in July and August. That's just, you know, part of doing business. And they'll get discovery, and they'll have a lot of discovery by June. Will they get all of it? No, because discovery, is an ongoing process, and the investigation to get evidence against Kohberger is an ongoing process. So it's going to be a while. They'll get a lot of information, probably swamped with information. They're going to need meaningful amount of time to go over that so they could actually give him the best defense that they possibly can. Yeah, if maybe it'll be put off. The only thing I might not put it off is possibly because the level of proof is simply probable cause. Once again, depending, I guess, really what they're going to do is probably depend on how much evidence they got, discovery they have. But yeah, it'd be it's a 50-50 bet whether it's going to be extended all the way through to September. And that might actually happen because once you get that preliminary hearing, the judge might, in June, the end of June, the judge might ask, "Are you ready to set a trial date?" And I think, as you say, Billy, most likely they're not going to be ready at that time to set a trial date. Probably not. I agree.
No, and the other thing we already spoke to was the bail, and I think we can agree, and I'm not going to say we can all agree because all of anything can never agree on anything, but I think we can agree that he's not going to get bail.
No.
Absolutely not. Not a defendant in a quadruple murder case.
Right.
There's no way he's going to get out because he's a flight risk.
Mm-hmm.
He's a danger to the community. He's all the things that all the boxes checked for why you don't give bail.
Sure. He's also
the other thing is,
himself.
Mike, you mentioned discovery, and I know that we believe as former investigators, former police officers, detective sergeants, that type of thing, that we believe the police have a hell of a lot more evidence than they're showing their hands at right now. Many people have asked in the chat, they were interested in why was there a gag order on the search warrant of his apartment in Parkman, Washington State. Why was there a gag order on what was recovered during that search warrant? Could you answer that?
Yeah, we don't know for sure, absolutely certain why the judge issued the gag order. I think it's very prudent to do that because it ensures that there won't be a media feeding frenzy for any of the information that might be contained in the affidavit and the list of property that may have been looked for and seized and discovered and is being gone through. I think I saw one station, one program opined that possibly the gag order meant that there was a co-conspirator of Kohberg's involved. I seriously doubt that. It's probably nothing more than a prudent move by the judge to ensure that people in the in that apartment complex where he was living for those couple of months, neighbors, and gave interviews to the police when people came knocking on his door, and their name is in the record as having made some statements. And the judge does not want these people to be harassed, alarmed, annoyed. On social media, we've all seen what happened to the food truck gentleman and the bartender. I won't even say their names because I don't ever want to repeat that, because these are private citizens who just happen to be involved, peripherally in this huge case. But I think that's probably a prudent order by the judge to ensure that everything goes smoothly. And when the judge is, prepared to lift that gag order, then we'll find out. But I think that's all it is, just to keep everything quiet and orderly and not to harass the public.
Mike, as less and less information does come out, and even more so when more information comes out, the broadcast media, as well as the internet and the talking heads and the content creators on YouTube and Reddit, all these different little chats, the information and the rumors just run rampant. And it's almost as if, I'll say this because I'm not a member of the broadcast media. They try to dictate the pace and what gets released and the slant that they put on what's happening within this case. And sometimes it can be quite harmful. And it's, we've seen during this case that the police, with I think they had over 12,000 or 14,000 tips. People don't realize they have to check every single one of them out. So people may say, the more tips, the better. That's not necessarily true.
Yeah.
Tips that are garbage, and that's a French word for garbage, don't help you, And if you get 12 or 14,000 tips, how many of those tips are actually good? How many of them are really coming from someone that knows something, or someone just calling up because they want to be part of this?
Right. The tips that police want, and they always want tips in every investigation. They always ask for tips, ask for help, but they're looking for tips that have some sort of where the person giving the tip has actually some sort of personal knowledge that they themselves have heard or saw, or said, that sort of thing. It seems that when you get an excessive amount of tips, like, over 10,000, a lot of it is third-party rumors that somebody heard somebody else say, that they possibly heard on TV from some sort of news program. And people are looking, it's like some sort of chaos theory. People are looking to connect the bartender with the food truck guy, with one of the girl's previous boyfriends, and all kinds of things. And it just gets to turn into a circus, and that actually hurts. I am sure the police have gone through so many tips, and probably 5% of them, perhaps, maybe, were useful. But beyond that, a lot of it is, as you say, pardon my French, garbage.
We speak the same,
Yes.
from the same region of France,
Right.
the New York City region of France. In the same vein as that, there was a report in regards to Reddit posts that had a lot of the information about this case that turned out to be true before it was released by the police. I want to play a little of Ashley Banfield right now. Again, in that same vein, I don't think that becomes helpful. They're trying to claim that this was Bryan Kohberger posting on Reddit about the case himself. Now, if that is true, there's a very easy way to find that out. And you don't have to be a rocket scientist to do that. A computer guy can check his his ISP address, right?
Right.
Excuse me, his IP address, Internet Protocol address, and see if it's registered to him. Boom, identification done. But it's sort of adding another dimension. Let me play a little bit of this instead of me talking about it. We'll see what they say about it.
A particularly savvy follower of the Idaho murders, who it sure seems may have had firsthand knowledge of the crime. Joining me now are retired FBI Special Agent Jennifer Koffendorfer, forensic psychologist Chris Mohandi, and trial lawyer Trent Copeland. Welcome to all three of you. Jennifer, I want to begin with you because as I've been reading these, I find very disturbing posts, almost braggadocious, as though this person knew exactly what happened in that house well before the affidavit told us some things about that house. I also felt like there was a similarity in the attitude and the writing style between the Facebook poster named Papa Roger and the Reddit poster named Inside Looking. Is that just me, or do you see that too? Because you look with a whole other set of eyes.
Well, there definitely is a similarity. Just as you said, in their style, in their confidence, in their details that indeed, in many instances, only the killer or the police would know. So from those standpoints, yes, you hit the nail on the head.
And if that's the case, they become a lot more evidentiary. I would assume, Trent, that all of a sudden, if I don't have the tools that the FBI has, the things that used to be in Jennifer Koffendorfer's suitcase are magic. They can subpoena ISP information, et cetera. But Trent, do you see that as something that could be just manna from heaven for prosecutors? If they can link accounts from Facebook to Reddit that brag about all these things and they're accurate, and they were well before that was made public, is that just sort of like, it's almost a smoking gun?
I think it is. And look, here's what's important. Not just that it was braggadocio, not just that it was, he had a keen interest in the case, but if it can be established that from the timing and the sequence that he knew things and he was, publishing things on Reddit as these various people that he claimed to be in these chat rooms, if that can be established, Ashley, that he knew these things before police knew them, before they were publicly available, then those things are huge from an evidentiary standpoint. And so this reminds me a lot of, the BTK killer. Remember him, Ashley? It was his bragging. It was him mocking the police. It was him sending floppy disks to the police about the crimes that got him arrested. And that was his undoing. So these things can have enormous evidentiary value. These things, killers of this nature tend to want the attention. They tend to want to be the smartest person in the chat room, so to speak. And in this instance, this could very well be another linchpin in addition to the DNA, in addition to the cell towers, in addition to all the other things that the police currently have. This could also be one other thing. And as you say, Ashley, it could really carry the day.
Mike, I agree that if this is Bryan Kohberger, it's very powerful evidence, but it's easy to prove. As we said, the FBI has tools that'll trace the internet service provider address, and if they can match the Facebook post to the Reddit post, and they identify that it's him, then it can absolutely be used as evidence. I'm sure a defense attorney would deny this to the end of time. Oh, it could have been someone using his computer, or it's not him. You know what I mean? But so is it that powerful of evidence?
Billy, if that's a huge if, and it's a monstrous if. And if it is true that it would show consciousness of guilt and would show his state of mind, taking ownership over that knowledge that only the police would at that point know and the public wouldn't know because it wasn't disclosed about the presence of the sheath with in the home. It's a big if, and I think they're hopeful that it is, because if again, I hate to keep using the word if it is, that's huge. But if it is not, then it's a big nothing burger And at this point, actually today, as we're talking, the FBI and the Moscow Police and the Idaho State Police have had his laptop, and they've gone through it. And and they could tell very quickly, go to that date and that time to see where he was on his computer. It's going to be something that they may already know if he is the poster of those messages on Reddit and, under an assumed name. But they're not going to tell the police. They're not going to make that public anytime soon. So although the attorney discussing this with Ashley Banfield was correct, if it is Kohberger, that's huge. But be prepared for it to be if not, and it's somebody else. And who is that other person? It could be someone who is friends of one of the officers involved in the case, who may have heard it from someone else. It's possible.
Mike, something in that vein, there was a lot of people that had information before it was officially out. And I know that for a fact.
Oh, yeah.
They had, there's a rumor that, I heard that people knew there was an eyewitness way before that was out.
Right.
So, there's people on this case on the law enforcement side,
Sure.
and there always is, that were talking to friends, family, and some to press. We know we always had all leakers to the press. Right. And someone told members of the press this, so they knew this. And I think John Miller from CBS even alluded to that. He knew some things before they were out there. So could that be someone that was privy to insider information that was not yet officially released by the police?
Yeah, I think more likely than not, that is absolutely true. It would be too good if it was, Kohberger himself. Be prepared for it to be someone, like you said, someone tangentially related. Maybe, just think about how many people are connected to this investigation between the detectives from Moscow, the Idaho State troopers, the FBI agents, you have people from the coroner's office, you have paramedics, you've got crime scene photographers, you've got fingerprint technicians, you got all of these people. And so they may have said something to someone, and that's huge. So I agree with you. It's probably most likely than not. If I had to bet my paycheck, I would bet it's someone tangentially related to the investigation.
Well, Mike, you're using some big college words there, tangentially, but that's
Sorry.
all right. We learn something something new every day. That's for sure.
I'm going to try to work in the word surreptitiously sometime.
Okay, yeah, I hope you do that, folks. This is Police Off the Cuff, real crime stories. If you like podcasts from a police perspective, then you're in the right place. We cover that from a police perspective. We try to follow the evidence and not be sensational. If you want to subscribe to us, please go on our YouTube, hit that subscribe button, give us a thumbs up, and ring that bell. And, share us with your friends. And please do comment. We love to read the comments. We love to answer the comments. And we appreciate the education and the intellectual manner in which our friends, our fans, our subscribers follow this channel. And we appreciate you guys. If you want to support us, we have a Patreon with 3 different levels. And we also have a YouTube channel memberships with, count them, 5 different levels. And you see the folks in the green font. They're part of our YouTube channel memberships. And we really appreciate all our fans, friends, and subscribers. I'm going to play a little bit more of this, and then we'll move on.
Yeah, I remember that moment where BTK said in court, just so matter-of-factly, every little detail, as though we were all just little pieces in his game board. And it was just joy for him to just hold us all in his grip for as long as it took him to spill out those vile details. I hope we don't have that in this case, but in the same sense, I hope we do, so we get the answers. But that's your bucket, Chris Mohandi. There was something else that Inside Looking wrote. I'm just going to read it out here. It says, all I'm saying is that the killer is not a registered SO, which is sex offender. I would bet all my chips on that. Not an SO came up in so many other posts. It seemed like he's fixated on that. And of course, what happened later? The police said, this isn't a sex crime.
Right. Well, again, it's possible, that a killer like this will, taunt in whatever methods available, whether it's a, Zodiac style, taunting that we saw using newspapers and so forth, or, some other forum like social media. It's also possible that, there's just other people out there that are arrogant and braggarts and so forth. But certainly narcissism is going to be a key feature of this kind of individual. And there was a certain pride that was in that statement of knowing with degree of certainty that would be consistent if indeed it's learned later on.
Thank you for watching. Go to newsnationnow.com to find.
Mike, that's one of the things, and I'm by far not a behavioral analyst. However, that's one of the things that I believe, and again, not being trained in psychology, I believe there is somewhere hidden in his psyche some psychosexual reason for these killings and these attacks. I mean, I think it's been said that Kaylee Gonsalves was targeted. Now, that's been said, it's been recanted, and it's been restated. But it seems, at the very least, females that lived in this house were targeted.
Right. He's not.
That would sort of imply a sexuality, a sexual component to this, even though there was no specific sexual attack.
No, true. He doesn't. He's not the rapist that people might think, or dragging some woman down an alleyway late at night, stabbing her, raping her. That sort of brutality. This is different, but because of the gender differences, he didn't attack 4 males. He attacked those 2 females on the 3rd floor, and the gentleman and his girlfriend on the 2nd floor, conodal. So yeah, there is that, because it goes cross gender. They may have some sexual aspect to it, and the fact that he probably has been rejected by many ladies in the past, and he doesn't understand why. He's got a fixation on women that way, that he finds them to be attractive yet dismissive. So in some ways, I'm not a behaviorist at all. I'm a cop and an attorney, but I think absolutely, that you cannot take that away off the table completely, that there is some sexual fantasy, anger going on in there somewhere. Definitely.
There is absolutely rage here. And, there's so many questions that folks have, especially about the evidence. And the big evidence, of course, has to be the DNA on the knife sheath, on the button that is used to open the knife sheath. There's a million questions. Was that DNA? What was the derivation of it? Was it touch DNA? Was it skin cells? Was it blood? The police never gave that up. They never said it's blood. They said they recovered DNA, which was matched to Bryan Kohberger's father, which was like a 99.5% match. Right. Now they get his DNA after he's arrested, because he's arrested. They can swab him and put it in CODIS, which is the FBI combined DNA index system. And now they have his DNA, his actual DNA, which of course lawyers would challenge if his actual DNA was never compared against the evidence at this crime scene. We compare it with potentially he left his blood at the scene, which 99.9% of all criminologists and crime scene experts think probably happened. And then we have, like, to me, that is what we're talking when we say slam dunk evidence. Right now, people are already making up excuses for the knife sheath. Oh, he could have left, someone else could have left it there or planted it. You have this craziness. But to dispel all of those rumors and all of those possibilities, you have more evidence, which is going to put him in the house. And then talk about transfer evidence. They find blood in his car. Come on. It's all over, Yeah.
Yeah. The idea that there's some sort of excuse for Kohberg's DNA being on the knife sheath, It's incredible. People like to, speculate, but yeah. In fact, could you just imagine a scenario where he touched the knife sheath at some point, and then someone who had some, malice towards Kohberger would kill the girls and then plant, the knife sheath there, figuring the police are going to get there and then get Kohberger's DNA. Well, that would be ridiculous. I mean, that's so far fantasy left field. That's if they get one drop of any of those 4 people, young men and women's blood off that car, it's over, lights out.
Conflicting report that has surfaced ahead of Bryan Kohberger's status hearing on Thursday. So Shannon Gray, who's the family attorney for victim Kaylee Gonsalves, he says that no one knew Kohberger before the murders. But according to last week's probable cause affidavit released by Moscow officials, Kohberger was in the area of the victim's home at least a dozen times before the attack. That information, which was gathered through cell phone data, also puts Kohberger at the crime scene hours after the attack. The 28-year-old was attending Washington State University at the time, less than 10 miles from the Idaho crime scene. Gray has previously said that the victims gave no indication that they were being stalked, but that if any of the families find any information connecting the victims to Kohberger, it will be turned over to police. A time the suspect could have visited the home was during one of their off-campus parties. You see, the home had a reputation as being a party house. In fact, police responded to at least 2 noise complaints just a few months before the murders. Body cam footage captures officers speaking with 3 of the victims, Kaylee Gonsalves, Madison Mogan, and Zana Kernodle, during 2 separate incidents.
Is this your place?
Yeah.
Perfect. You know why we're here?
And I assume noise.
Noise, yeah.
Yeah.
Big speaker right there.
Yeah.
Nothing against having a party. Once neighbors start calling in, then we have an issue.
Fair.
So usually, at least for me, I'll give you a verbal warning.
Okay.
Once I have neighbors calling in, your music's too loud. You're disturbing the peace.
Yeah.
Nothing against having parties. Nothing against having people over who are overage to drink.
Mhm.
But again, once we start disturbing the neighbors, then we've got an issue. This is your place, so I'm going to hold you responsible. Because it is your place, you're also responsible for everybody here.
Yeah.
So I'm going to grab your info.
Yeah.
And if I do have to come back here, a $300-some ticket's coming your way.
Okay.
And it only gets more expensive from there. Is that fair?
Yeah, that's
Okay.
fair. Absolutely.
All right, Madison. So here's the deal. Okay. They've already said that no one here lives, none of the occupants that live at this address are here right now. So now you have a house full of random people. You need to let them know that the noise needs to come down. Okay. We just received a noise complaint. We want that music.
All right, we get it. It was a party house, and there can be all kinds of skin cell DNA, touch DNA, maybe even blood DNA about the house. But that doesn't change the fact that the defendant's DNA is seen on a knife sheath that's found on the bed where someone was murdered. 2 people were murdered in that bed. That doesn't all the DNA in the world. I mean, look, I'm oversimplifying it. A defense attorney will use that as to create doubt. Milwaukee civilian, thank you for the $10 super chat. I'm not blaming victims, survivors, but are you guys as baffled, concerned by the affidavit's comments about the survivors' interaction with BK? Mike, I'm going to let you answer that.
Given the fact that that we saw the affidavit, all the facts in the affidavit, and look at everything chronologically, no one knows how we would react to that sort of event. That's in our house, in a house that we were renting that was known to be a party house. We're not sure exactly from the affidavit all of the transactions that went on and all that the 2 surviving young ladies witnessed. We just don't know. To sit there, and I don't want to sit in judgment of them. They'll have to explain their actions. And remember, it's set against the backdrop of a 4 a.m. wake up after a night of partying and drinking and that sort of thing. So that always has the context in which something happens always has to be taken into context. But we you, me, and everyone else, we may do things that later on in hindsight may seem to be inexplicable or dumb, ridiculous or intelligent or amazingly smart. This is what we have to deal with. This is people's reactions, and you can't go back and replay the tape and try to psychoanalyze these young ladies that were left in the house. They saw something or saw some things and didn't see other things, and were aware of some things and weren't aware of other things. And we should just let it go at that,
Absolutely. Folks are asking about the bloody shoe print in the house. And I just want to point out that initially it was found the second day of the crime scene process. So initially they didn't find the bloody footprint, and it's the bottom of a Vans shoe, a Vans type shoe. They used a chemical called amino black that raised up the blood, and it was able then to be seen. Now, I've spoken about this before, and I won't belabor it, but there's something called class characteristics to evidence and individual characteristics. The class characteristics, again, I feel like I'm going over this every day, but it's okay because there's new people listening. Class characteristics for a Vans shoe are a very specific bottom impression that very specific shoe would leave in blood. Now, the individual characteristics are how the individual wears out his shoes, his or her shoes. I know I wear out my shoes to the left. I don't know. I guess I lean to the left when I walk. But also on the bottom of a shoe is something called pits and fissures, F-I-S-S-U-R-E-S. That's like from stepping on rocks, glass, other things, and they leave marks that are almost like identifiable like a fingerprint. So if they recover this shoe from the defendant's house and compare it against this bloody footprint and it matches perfectly, it's very, very, very powerful evidence.
Yeah. Bill, I just wanted to talk about the defense attorney's role in this when it comes to questioning witnesses and their presentation before the trial jury. Remember, the prosecutor has a huge burden. They have to prove each and every element of the crime, what we call the corpus delicti. They have to prove that each and every element of the crime beyond a reasonable doubt.
Right. You know something? Someone the other day basically praised us for defining that. And the corpus delicti is not the body.
No.
It's the body of the crime.
Right. All those ingredients.
We defined that the other day and people were like, oh, I didn't know that.
Yeah.
So explain that, Professor Geary, before you move on.
Okay. All the elements of the crime, when that person committed it, that fact that the person committed it, how they committed it, where they committed it, the tools that they used, how they get in, how they escape, all of those little factors have to be proven to a trial jury beyond a reasonable doubt, which is the highest level of standard of guilt that we have in our system. So you have to convince 12 people that there's really no reasonable doubt that anyone else could have done this at this time, in this place, in this manner, other than the defendant sitting in the courtroom. The defense attorney really only has to try and convince one out of the 12 people that there is some reasonable doubt, just a little bit of reasonable doubt in their minds where they might think, it is possible that someone else may have done this. And so the defense attorney only has to convince one, the prosecutors only have to convince 12. And the prosecutor has to prove guilt beyond a reasonable doubt. And the defense attorney only has to prove to one person that there is the presence of some doubt. Very different burdens at the trial.
The other thing, though, Mike, is that what everyone also that's listening needs to understand is that the prosecution has what's called the totality of all the evidence. So when all of the evidence is considered, not just one thing, it's extremely powerful. And a defense attorney may choose or will choose to attack each and every bit of evidence that was presented either as the trial goes along or in his or her summation.
Yeah, the defense attorney, has the burden of trying to convince the jury that there is reasonable doubt. They have to zealously advocate for Mr. Kohberger. To do anything less would be a violation of their rules of ethics. So it's going to be a dogfight in that courtroom. absolutely. For each and every piece of evidence that is presented and each and every witness that is actually testifying. Remember, Billy, you and I know, and a lot of people might not realize it, but this is a totally circumstantial evidence case. DNA is circumstantial evidence. Seeing someone perhaps enter a building or leave a building or hear a scream inside a building, things like that, that's all circumstantial evidence of guilt. It's not direct evidence of guilt. And so therefore, the defense is going to try as best they can to show that there is some doubt in some of that evidence, and try and hang one juror. But as you say, the prosecutor will tell the jury in his summation that, look at the totality of the circumstances, the look at everything all together, and taking it all together, use your common sense and decide what you think. In the prosecutor's opinion, would lead to a conclusion that is Bryan Kohberger. But yeah, it's going to be one heck of a dogfight in that courtroom.
Mike, circumstantial evidence, as we know, as former members of the service, when there's a lot of it, it's very, very powerful evidence. It's not as good, of course, as the smoking gun or confession or someone actually witnessing it. But I want to talk a little bit about a DM, the roommate who actually was on the second floor that night. We're learning that now. How good could her eyewitness identification be? And I just want to explore this a little bit, because we all know people have a certain aura, a certain gait, a certain way they move, a certain way they look. And even if you don't see their face, there are other identifiers to that. Body type, how tall was the person? In this, the eyewitness talks about bushy eyebrows. The shape of the face, you could see the shape of the face through a mask. So how good is that eyeball witness? And also, the same eyeball witness is an ear witness. She hears what we think is the perpetrator say, "Oh, it's okay, I'm going to help you." So not that I spoke to, I don't think any prosecutor would take the chance and do what's called a voice lineup.
Right.
Because if they did a voice lineup and the witness failed to choose the correct voice, they would lose that as evidentiary information, and it would hurt them more than help them.
Right. And a defense attorney would jump all over that to say, look, if the person was only 3 feet away from them and it wasn't any other noise, and they heard this voice, and now they can't be sure if it's the same person's voice, that's reasonable doubt right there, ladies and gentlemen of the jury. That's reasonable doubt. And if that's reasonable doubt, then consider everything else that she said with a grain of salt. It's reasonable doubt. It's going to be very difficult for, as she said, identified as DM in the affidavit. If I'm the prosecutor, I want her up there first, and I want her to tell her story, and I want to get the jurors' attention immediately with the humanity of her story. I don't want to put up a DNA expert as the first witness. No way. You want to capture the surviving young lady and have her discuss the events of that evening before, during, and after. And the fact that she actually can describe his eyebrows shows that there was enough light in there to make an identification. She will get beaten up a little bit, obviously, by the defense to, about maybe perhaps the presence of alcohol. Yeah. And that's understandable. And, everybody's, will understand that. All the jurors will understand it. The prosecution will lead her through her direct examination. And then, the defense attorney absolutely has a right to, attack her credibility. They'll do that probably as hard as they can, but also risking perhaps alienating members of the jury. Because if you are a person in that jury who may look at that young lady and say, she's probably very sincere, but given the fact that it was 4 a.m. and she had drank a lot of alcohol, I'm not calling her a liar, but maybe perhaps she really didn't see what she thought maybe she saw. You might get one juror that will, do mental gymnastics and bend logic into a pretzel in order to give Bryan Kohberger the benefit of the doubt. I hope not, but you might. But she is going to have to explain her actions. But again, I think the jurors will be very forgiving of her because she's a young lady, and it was a confusing set of circumstances.
And I think that the defense is going to have to interview her or cross-examine her very gingerly,
Yes.
or the jury would not appreciate a scathing cross-examination and a pointing the finger at examination.
Right.
Another big question is, a lot of people are asking, is did any of the victims know Bryan Kohberger? Now, the only one that really knows the answer to that are the police. And what they, of course, would be checking social media. They'd be checking maybe interactions in the restaurant that, who was it, Kaylee worked at with?
Yes. I think Ms. Mogan too worked there.
Mogan, yes. She worked at the same restaurant. So was there any interaction at that? Was he ever, which would help the defense a lot, was he ever at the house? Is there any possibility? So the prosecution, the police, have to slam the door on that. They have to shut that down. Let me play a little bit of this and see what the family says.
For the attack. That information, which was gathered through cell phone data, also puts Kohberger at the crime scene hours after the attack. The 28-year-old was attending Washington State University at the time, less than 10 miles from the Idaho crime scene. Gray has previously said that the victims gave no indication that they were being stalked, but that if any of the families find any information connecting the victims to Kohberger, it will be turned over to police. A time the suspect could have visited the home was during one of their off-campus parties. You see, the home had a reputation as being a party house. In fact, police responded to at least 2 noise complaints just a few months before the murders. Body cam footage captures officers speaking with 3 of the victims, Kaylee Gonsalves, Madison Mogan, and Zana Kernodle, during 2 separate incidents.
Is this your place?
Yeah.
Perfect. You know why we're here?
And I assume noise.
Noise, yeah.
Yeah.
Big speaker right there.
Yeah.
Nothing against having a party. Once neighbors start calling in, then we have an issue.
Fair.
Okay.
I'm so sorry.
It's okay. I just hope for your sake that your friends don't put you in a position where you get the citation and you have to go to court to defend yourself from your friend's behavior. Make sense?
Just so chilling seeing them there only a few months before this. So I'll bring back in Brian and Terry on this. So Terry, the affidavit places Kohberger near the house numerous times before the murder, but surviving roommates didn't know him. So if you were the prosecution, how do you explain that?
Well, a couple things here. First of all, if he's near the house, but outside the house, what the prosecution is going to have to argue is he was casing the house. He was going around trying to figure out what are the entrances, what are the exits, how can I get in? So that's one possible explanation for his being there and the victims not knowing him because he never entered the house. But as we saw in those clips, there were multiple parties at the house apparently, and there were noise complaints. So it could very well be that he was inside the house because those cell towers put him in that area. If he's in the house and there are lots of strangers, then perhaps we just don't know whether or not any of the victims literally ran into him. There could have been 100 people in there, and they could be all people from the school, and they don't know everyone who is in that school. So I think they would have to basically say they didn't run into him, and the prosecution is going to have to prove that that was what exactly happened. He might have been in the house, but the victims didn't see him.
If he was in there, he just would stand out. He's older, he looks different. So, Brian, let's go back to that hearing that's on Thursday. What should we expect from them?
Well, it's a concern, but it is a possibility that they had an encounter or encounters with him. And the police really need to probably slam the door on that and close that door that the defense is going to try to open.
You know what, though, Bill? Even if they can't slam the door on it, and there is a possibility that, the defense can claim, yeah, he was there, and they may do that and say, yeah, he ran into Ms. Kernodle, Ms. Gonsalves, Ms. Mogan, and Mr. Chapin somewhere along the line. Maybe they don't remember him. Maybe he was just there once. To me, it's not a case killer whatsoever, because in the end, yeah, you might have a fingerprint there, you might have a footprint there, or you might have a hair DNA, but there's no way that you're going to be able to explain away that DNA on that knife sheath in that bedroom, lying there with 4 young people slaughtered. So you can't, you got to go as a prosecutor, you got to go with the case that you have. And as you know, in many cases, there are some unanswered questions that you just don't know the answer to. You would love it. You would love that as a squad commander, to have, every single I dotted and every single T crossed in every single case. And there'll be cases where there may be some unknown facts.
Absolutely.
You got to go with it no matter what.
If you're looking for a great attorney in the New York City metropolitan area, Joe Murray's your man. He's a retired member of the service, NYPD police officer, and he's a big supporter of Police Off the Cuff. If you want to reach him, his cell phone is 718-514-3855. His email is joe@jmurray-law.com. His website is jmurray-law.com. Joe Murray is a fantastic attorney and a big supporter, a huge supporter of Police Off the Cuff, and we really appreciate his support. Folks, this evening, we're going to actually come on and do a double header. Unfortunately, Mike Geary has a life and has declined to come on at 7 o'clock. But tonight at 7, we're going to have our straight out of Brooklyn retired NYPD detective Phil Grimaldi. And we're going to have former Brooklyn District Attorney and Chief of the Brooklyn Homicide Squad, Michael Vecchione. That's at 7 p.m. We're going to do a little bit of a deeper dive into this. I mean, look, this case is fascinating. There's a lot of things that are going to come up that we don't have the information on right now, but it's going to come out, and we'll keep explaining it to you guys as to what occurred. I always want to mention, sometimes we lose sight of the fact that these are real people. And these 4 students that were slaughtered, Ethan Chapin, Zaina Kernodle, Madison Mogan, and Kaylee Gonsalves. And we can't ever forget that they lost their lives on November 13th. In the same vein, I have to say this at every time, that Bryan Kohberger is innocent till proven guilty. And in our system, he'll get his day in court. And we'll follow this case all the way through. As we said, the next court appearance is June 26th. And there's a good chance that when they appear in court on the 26th, they'll have the whole case put off till September. Because in law enforcement, pretty much no one wants to work over the summer. And unfortunately, that's the way things go. But that could definitely happen. Mike Geary, I want to thank you so much.
You're welcome.
For bringing your form of calmness, intellectualism, and knowledge to this case. It's very much appreciated. And when I read the chat and how much people appreciate you, it's a great thing. Mike, final words.
Final words. Just keep in mind, as you say, Ms. Gonsalves, Ms. Mogan, Mr. Chapin, Ms. Kernodle, just keep them in mind. This is what it's all about. And, just please don't listen to crazy rumors online and things like that. If you have questions, about police procedure and stuff, ask us. We'd love to answer them. This is what we do. This is our bread and butter for many years. So don't listen to internet sleuths and things like that. Come to where we give you some good, accurate information as we go through this case.
Well said, Mike. Folks, thank you for tuning in today. On behalf of myself, retired NYPD Sergeant Bill Cannon, and retired Sergeant and Professor Mike Geary, have a great day. Stay safe and God bless.
Take care.